Good afternoon to you. Today we will continue with the Constitution class. This relates to constitutional amendment procedure. We will see to what extent the constitutional amending process is flexible or rigid. We have already seen what is flexible, what is rigid. Now we will see how much it is flexible with reference to our constitution specifically. In the last class we have seen the details of amendments which are not treated as amendments for the purpose of Article 368. We have seen 11 or 12. We have in particular seen how the new states are sought to be created, sought to be established, sought to be reorganized, sought to be changed, the boundaries altered without the consent of the states. We send it and states give their views, that's all. No consent is obtained. Even though these amendments amend the schedules and the provisions of the Constitution, these are not treated as amendments for the purpose of Article 368. This is the most important point you should remember. Now, we will see the two specific methods of amendments projected in Article 368. I told you there are two methods. What are these two methods? That we will see in this class. Under the first method, kindly follow closely, it's very important. Under the first method, the constitutional amendment bill, that is the legislative proposal, can be introduced in either house of parliament. Understand? It can be introduced either in Lok Sabha or Rajya Sabha. Secondly, also understand that no recommendation of president is required for introduction in either house of parliament. Most of the people have the confusion that like money bill, president's recommendation is necessary for introducing a constitutional amendment bill. No, there is no need for presidential recommendation for introduction of a constitutional amendment bill. Now, the above amendment bill should be passed by both the houses of parliament by special majority. What is special majority? Special majority means absolute majority. That is total number of membership of the house divided by 2 plus 1. This is absolute majority. And plus additionally, that is 2/3 majority of the members present and voting. Both the conditions should be satisfied. For special majority, both these conditions, absolute majority as well as 2/3 majority of the members present and voting should be satisfied. After the bill having been passed by both the houses of parliament by special majority, it will be presented to president for his assent. It will be presented to president for his assent. Upon the bill being presented, remember, the president shall have to give his assent. Please note, 24th Amendment Act 1971 made it obligatory for the President of India to give his assent. He cannot exercise any sort of the vetoes. That is, the President cannot exercise absolute veto or suspense veto or so-called pocket veto, which are normally exercisable in the case of ordinary bills, including money bills. President cannot exercise any of these vetoes in respect of constitutional amendment bills by virtue of 24th Amendment Act 1971. Upon the bill being assented to by president, the bill becomes an act. When the bill becomes an act, upon both the houses of parliament passing by appropriate majority and the bill being signed, approved, assented to by president, the bill becomes an act. When the act is notified by the government, the act becomes a law. The act becomes a law. This is the first method. Remember, this is the first method. Now, second method is prescribed for amending the provisions of the Constitution which relate to federal features of the Constitution. I have already told you, we have a federal Constitution, we have the federating units, we have the states and we have the center. So, there are federal features of the Constitution. Such provisions have been expressly given in Article 368 itself. Article 368 itself gives you what are all the federal provisions for which the special procedure is required in addition to the majority passage of the bill. What are such federal provisions? Number one, manner of election of president. Number one. Number two, extent and scope of executive powers of the union and state. Number two, Supreme Court, High Court, and High Courts in union territories. Number three, that is union judiciary and state judiciary. Number four, distribution of legislative powers between the union and the states, including 7th schedule. Then representation of states in parliament. Number 5. Number 6. Procedure to amend the constitution, that is Article 368 itself. In these cases, the bill can be introduced in either house and it should be passed by both the houses of parliament by special majority as explained in the first method. After the bill having been passed by both the houses of parliament by special majority, the bill has to be referred to the state legislatures. Underline. After having been passed by both the houses of parliament and before being presented to the president for his assent, these bills have to be referred to the state legislatures. After the bill is ratified by at least half of the state legislatures through a resolution to be passed by such state legislatures by simple majority, then such a bill will be presented to president by president for his assent. At least half of the state legislature should approve. Remember, most importantly, if there are 28 states, at least 14 states should approve. At least half of the states should approve. And how they will approve? They will approve by simple majority. Once the bill is ratified by half of the state legislatures, the bill will be presented to president who shall give his assent, upon which the bill becomes an act. The bill becomes an act. Most important. According to the rules of procedure of Lok Sabha, according to the rules of procedure of Rajya Sabha, special majority is required at all stages of the passage of constitutional amendment bills. What are the various stages of passage of the bill? Number one, reference to the parliamentary committee. Reference to standing committee or parliamentary committee or select committee or any committees. Reference to the parliamentary committee. Number one. Number two, adoption of the recommendation of the committee. Number two. Number three, consideration. Number three. Number four, class by class discussion and each class being voted. Number four. Number five, amendment proposed for each class. Number five, voting in the third and final stage. In all these stages, special majority is required. It is not given in the constitution, but it is given in the rules of procedure of Lok Sabha and Rajya Sabha. Remember, it has been held by the Supreme Court. It has been held by the Supreme Court that the amending powers of the Parliament includes the power to cede territory to a foreign state. As I have already told you in the first class, Perubari case. Under under the advisory jurisdiction, President of India referred the matter, the Perubari decision, Supreme Court decision on Perubari case, that the power to amend the constitution includes the power to cede territory to a foreign state. Similarly, the Bangladesh, we amended the constitution. Secondly, it has been clarified in class 3 of Article 368, added through 24th Amendment Act 1971, that nothing in Article 13 shall apply to any amendment made through Article 368. In other words, the amendments made under Article 368 are immune from judicial review under Article 13. What Article 13 says? The state shall not make any law which takes away or abridges any of the rights conferred in Part 3 of the Constitution. if any law is made taking away or abridging any of the rights conferred in Part 3 of the Constitution, that law, to the extent of repugnancy, is null and void. This is the judicial review. That is verifying the, examining the, scrutinizing the constitutionality or otherwise of any law made by the Parliament. This power has been given to the judiciary under Article 13. So, the total embargo that the state shall not make any law which takes away or abridges any of the rights conferred in Part 3 of the Constitution. If any law is made taking away or abridging any of the rights conferred in Part 3 of the Constitution, that law, to the extent of repugnancy or inconsistency, it is null and void. This is the judicial review given in Article 13. So, it has been clarified in class 3 added through 24th Amendment Act 1971 that nothing in Article 13, which I have told you, shall apply to any amendment made through Article 368. In other words, the amendments made under Article 368 are immune from judicial review under Article 13. Under Article 13, in nutshell, the constitutional law is not subject to judicial review. That's all, very simple. That is, the protection given in Article 13 does not apply to constitutional law. So, the law mentioned in Article 13 does not include constitutional law. We will discuss in detail these cases in Sajan Singh case, Shankari Prasad case, Golaknath case, Kesavananda Bharati versus State of Kerala case and Mineral Mill case separately in the next class. For the present, remember, this provision is immune from judicial review. Secondly, that is 42nd Amendment Act 1976 added two more clauses in Article 368. Two more clauses. What are the clauses? Clause 4 of Article 368 added through 42nd Amendment Act 1976 provided judicial immunity to all constitutional amendments made before or after the 42nd Amendment Act, and categorically stated that these amendments cannot be questioned in any court of law. Remember, emboldened by what is known as the 71 victory, Mrs. Indira Gandhi added this through 42nd Amendment. What does this say? Any amendment made before 42nd Amendment Act or after 42nd Amendment Act cannot be questioned in any court of law. This is the judicial immunity given to all amendments made before or after 1976. Number 1. Number 2, class 5 also added to the Article 368, which was also added through 42nd Amendment Act. It sought to clarify and assert that there is no limitation for Union Parliament for amending the Constitution to any extent. That is, the Parliament is competent to delete, add, modify, overhaul any provision of the Constitution, and such an amendment cannot be questioned in any court of law. So, the Parliament has been given immense powers in this provision. That is class 5. Fortunately or unfortunately, Supreme Court declared that both class 4 and class 5 of Article 368 are null and void because judicial review is a basic structure. So, you cannot take away the basic structure which is the judicial review. So, Supreme Court declared both these clauses are ultra vires to the Constitution. So, now without this you have to read the Constitution. Now, these cases, in the next class, we will examine the amendability of the Constitution and also various cases which include Sajan Singh case, Shankari Prasad case, Golaknath case, Kesavananda Bharati case, Mineral Mill case, etc. We will see in the next class. Thank you.